Lordship's kind permission. But yesterday I mentioned I'll give a chart. I just prepared it for your Lordship's convenience. Severable, non-severable. And maybe after the others finish, I can just explain it.
Yes, please.
Yes. I made severable, non-severable, then within subparts. But I'll explain it after the others finish.
All part of your argument.
Pardon me?
All part of your
No,
argument.
I just want a chart so easy to follow, not so that's why.
I catch up.
No, the only thing is, in 34.4, we have not addressed the meaning of the word appropriate. I don't want to interrupt others because when I come, the 34.4 as the word appropriate, it's not necessary, it has to be sent back. The court may find it inappropriate, the court may decide itself. That point I'll clarify later.
Yes, please.
Please, my lords. I want to repeat what has already been argued previously. Just run through it quickly. I think your lordships have already heard enough of us. We have an opportunity right now to really set right a problem which we've been plaguing us for the last 20 years. Litigants being run between court to tribunal and vice versa. Or do we dig ourselves our heels inside and say, sorry, there's nothing that we can do. This is how the system is. We submit it's the former. That is an imaginary problem. Section 5 is not really a valid answer to the problem. Section 5 is actually a gateway, not an obstacle. Section 5 permits a Section 34 court to intervene in any manner it wishes to once the gateway is open. Because Section 5, the last part of Section 5 reads that the court may intervene where so provided. It doesn't say in the manner so provided. The reading of Section 5 is only a gateway to get inside, and once that opportunity is there, whatever powers the court wishes to apply are available to it. It appears at the end of Section 5, my lord. The second is, to what extent should there be corrections permitted to an arbitration award? And we submit, and this is a very important aspect, because if your lordship's hold is it should not be done too widely, because we'll have another problem being opened. We submit it should be restricted to certain aspects only. Number one is when there is a non-discretionary aspect, that is either there is a statutory right or a contractual right. One. Two is if it is a matter of modification of an interest. And three, if there's any calculation related errors. Now, it is why this is so important is because it leads to the entire concept of enforcement of rights, what a statute provides. If the tribunal is not either rightly or wrongly ordering that, awarding that, if a court does not correct that, it puts a big question mark on ease of enforcement of contracts, on the rule of law that we're enjoying. Because then the moment you see litigation dragging on, somebody going from court to tribunal, it casts a question on our ease of doing business in India, which is why there must be certainty, finality, and efficiency in the entire process. Therefore, these are from a policy perspective. I think the legal points have already been very adequately covered by my learned seniors. Now, we've tendered a note. In that note, my lord, we've already dealt with the series of judgments which already my learned colleagues have dealt with as to where the court has previously interfered with awards. The only relevant one I want to show, my lord, is the Hindustan Zinc versus French coal carbonization. In that, the Section 34 judge modified an award. A Section 37 judge, the 2006 4 SCC, the Section 37 judge set aside the Section 34 order on the basis that it should not have been modified with. The Supreme Court said
Page number.
2006 4 SCC 445.
2006.
2006 4 SCC 445. Hindustan Zinc versus French coal carbonization, where the Supreme Court upheld the Section 34 order allowing the modification. And that is the correct system we submit that must be followed.
But what was the modification made? What was the modification made?
Yeah. That was on the main merits of the matter it had gone on to, on the calculation of the damages.
Computation of damages. Where is the reasoning given? But without reason, they just applied.
Para 25, 24 onwards. The basis of the calculations.
It is on the basis of calculation.
Last line, the order of the division bench is unsustainable as it fails to interfere with a portion of the award which is opposed to the specific terms of the contract On the other hand, the trial court had correctly decided the matter. So in that category of if it is a contractual right, statutory right, interference must be there. If it is calculation of an error, interference
Right, then you're rewriting the award.
only to this limited extent where there is no discretion.
No. When
Yes,
say
Pallav.
in a contract says no escalation, come what may,
Then there is no discretion.
even if we extend the time, arbitrators normally find a way to get over these clauses.
Correct.
Because in equity, these clauses are one-sided, completely one-sided. There's a valid form contract.
So if the court feels that
If we do that, then virtually we'll be rewriting the award.
So just to correct, rewriting the award to a limited extent is not a bad thing. Rewriting the award up, because if one follows a policy that no rewriting is the policy which is being advised by the other side and is the one that is causing the problem. So partial rewriting in these limited circumstances should be permitted for a systemic benefit is what our submission is. So if there is a discretion to the tribunal, then court should not interfere. But if there's no discretion, if there's a contractual right, statutory right, then the court must interfere in those cases. We have to lay down limits.
Will setting aside include that part?
So that point has already been adequately addressed. So setting aside includes that limited right of modification and modification not quite, but with this limited aspect. My lord. Main point is the huge expense, effort that parties have undertaken.
Okay,
to be
fine.
nipped into
That's
the
all.
bud. Just 2-3 more points, my lord. There's another risk of this section 34(4) I'll just address. Is this if a court refers it back to the tribunal and tribunal maintains its view, this is the risk of an infinite bounce. It will come back in a 34. 34 may again hold its view. It's again a never-ending process, litigant suffering right throughout. Again on 34(4).
So already argued so many times.
I just make 2 more points. 34(4), 90% of the entire work is already been completed. Why not just finish it instead of sending them back all the way to this? And then many times the lordship should have seen tribunal is no more available either because of age or retirement. So a lot of practical difficulties are there in referring matters back to tribunal. So it is best from a commercial as well as practical and legal that the matter be closed at that stage. So we've seen it. They provide for the power to modify